Hey everybody, welcome to my YouTube channel, Foreclosure Help 777. You can join me on my Facebook group, Sue Your Lender, Fight Foreclosure and Mortgage Fraud. Today we're going to talk about a really interesting win. One of our fellow foreclosure fighters won his appeal. This is Wells Fargo Bank versus William Carrington. We're going to talk about what happened with his case today. He appealed his foreclosure case and basically won it. And so here, let's talk about what happened. This is in the Supreme Court, the Appellate Division, 2nd Department in New York. Decided on November 8th, which was just a couple of days ago. These are the judges in the Appellate Division that looked at it. And it says here, decision in order. In an action to foreclose a mortgage, the defendant, William Carrington, appeals from an order and judgment of foreclosure and sale, one paper, of the Supreme Court, Kings County, dated August 21st, 2019. The order and judgment of foreclosure and sale upon the order of the same court dated April 18, 2018, inter alia, granting the plaintiff's motion for summary judgment on the complaint insofar as asserted against the defendant, William Carrington, to strike that defendant's answer, affirmative defenses and counterclaims, and for an order of reference, and upon an order of the same court dated September 4, 2018, among other things, referring the matter to a referee to compute the amount due to the plaintiff, and upon an order of the same court, June 20, 2019, inter alia, denying that branch of the defendant's motion, which was to pursuant CPLR 5015A3, to vacate the order dated September 4, 2018, and upon an order of the same court dated August 8, 2019, granting the defendant's cross motion to confirm the referee's report for judgment of foreclosure and sale, among other things, confirmed the referee's report, directed the sale of the subject property. Okay, so basically, in a nutshell, he was granted, the bank was granted summary judgment motion, and William appealed the case to the appellate court. So now it's saying, ordered that the judgment of foreclosure and sale is reversed on the law with costs. Those branches of the plaintiff's motion which were for summary judgment on the complaint insofar as asserted against the defendant, William Carrington, to strike the defendant's answer, affirmative defenses and counterclaims, other than the affirmative defenses alleging violation of the Truth in Lending Act, 15 U.S.C. 1601, fraud and unconscionability, and the counterclaim alleging violations of the Truth in Lending Act, and for an order of reference are denied. The orders dated April 18, 2018 and September 4, 2018 are modified accordingly, and the order dated August 8, 2019 is vacated. And that order, August 8, 2019, that was vacated was the actual summary judgment. So basically this case gets reversed, remanded back to the state court. Now let's find out why it was reversed. Let's see here. Okay. Basically, September 4th, 2018, in an order dated August 8, 2019, the court granted the plaintiff's cross motion to confirm the referee's report and for a judgment of foreclosure and sale. On August 21st, 2019, the court issued an order and judgment of foreclosure and sale, inter alia, confirming the referee's report and directing the sale of the subject property. The defendant appeals. Whereas here the plaintiff standing has been placed in issue by the defendant's answer. The plaintiff must prove its standing as part of its prima facie showing on a motion for summary judgment. Deutsche Bank National Trust versus Galati. And they're talking about case law here. Plaintiff establishes its standing to foreclose a mortgage by demonstrating that when the action was commenced, it was either the holder of or the assignee of the underlying note. And then there's more case law we can talk about, saying that the attachment of a properly endorsed note to the complaint may be sufficient to establish prima facie that the plaintiff is the holder of the note at the time of commencement. However, here the plaintiff failed to establish prima facie that it had standing to commence the action. In support of its motion for summary judgment, the plaintiff relied on an affidavit from Daniel Del Pesci, an employee of Aquin Loan Servicing, hereinafter Aquin. The loan servicer, Despech, averred, among other things, that based on his review of Aquin's business records, the plaintiff had been in possession of the note since February 23, 2007, prior to the commencement of this action. However, the plaintiff failed to attach the business records upon which Despech relied upon his affidavit. So basically, the bank does not have standing, even if affidavit from a robo-signer is not going to be enough to prove standing. And the note itself was blank. It wasn't even endorsed by anyone, and they tried to bring in some allonges that weren't even attached to the note. They just stood by themselves. Let's look at his file in the docket here. If you want to look this up, guys, I suggest you do. It's an educational experience to look at this. The case number is 11234-2009. You can find it at the New York State Court. You can see the website address here. Go to the main page, the iapps.courts.state.ny.us. That's the main page. And from there you can do a case search. You can search by, you don't have to create an account. You can search as a guest. Just put in that number and the year, and it brings it right up. And you can look on 5709, that's when the foreclosure complaint was filed by the bank. And you can see that he filed a reply, answer, and counterclaims on 6/29/09. And it keeps going. There was the notice of appearance by different attorneys at this point. There were orders that were issued by the judge. Then they changed hands again. There was some discovery that was going back and forth with discovery. And then if you go all the way down to the end here, you can see on 9/10/2018, order granting summary judgment, dated 9/4/18. That's the order that they vacated in the latest. So this case is going right back to state court. They don't have standing, and they never will have it with a blank note. Just so you guys know, this is the kind of crap they pull to try to steal your house. And I think this is a very interesting case. If you wanted to read the back and forths of the motion so you can see what happened. But the bottom line is, he appealed his case. Even when they granted summary judgment, he did not just let it go. He appealed it, and then he won his appeal. And it looks like there's nothing else that the bank can do. And it's been 15 years, by the way. And statute of limitations will kick in. He's probably going to get his house. And the other side is going to probably want to settle this out of court so this case does not become precedent to other cases. Anyway, I know you guys want to know what happened with this case, and it was very good news for Carrington because it looks like he's going to win his house free and clear. So, if you have any questions, guys, leave them in the comment section. I hope that you will share this with others and subscribe to my channel. And thank you for watching.